Hey, it's Bill Gross, the LA probate expert, and this is part of my continuing series on probate and trust administration experts across the country, practitioners and as attorneys and as vendors that help us be more successful, help families and help attorneys refer across the country. Really excited today to have a attorney and his key member, staff member from Houston, Texas, attorney Bowen or Bo Bowen. Say hi.
Hello,
Bo.
everyone.
And also Lena Cervera, who is, I guess, part of the team and handles really more of the day-to-day administration of the probates for the families. How you doing, Lena?
Good. How are you?
Fantastic. So Bo, or Bowie, just off the bat, because I'm curious, tell me about the two dots over your E, and make sure we get your name pronounced properly.
Yes, sir. It's an umlaut, and so it makes it sort of pronounced more like Zoe. So it's more Bowie. But I've been going by Bo for so long, I kind of forgot they were there myself.
Okay, well, I couldn't help notice it on your Zoom identification. And Lena, what's your role with the firm? What do you do specifically?
So I do probate, estate planning, and then I also do civil litigation as well, and some business startups.
And so, are you an attorney or a paralegal, or what's your role?
I'm an attorney.
Oh, very nice. Okay, well, you look too young for that, so it looks like you
Thank you.
graduated law school underage or something. So, give us an idea, Bo. We'll start with you. How'd you get into? Where'd you grow up at? And then how'd you get into law? And then specifically, how'd you get into estate law and probate related?
I've been a little bit all over. My dad was a veteran as well. I wanted to be an attorney since I was knee high to a duck. I literally remember trick or treating.
Well, hold on with that. I'm from California now. From when you were what to a what?
It's a good country saying. Since I was knee high to a duck.
Okay.
So we're meaning way down there.
No, I got it. I figured it out once I heard it. I just couldn't believe it. Go ahead.
So I literally was trick or treating with a backgammon case and wearing my Sunday's best suit. It started from there, and then of course I discovered about law school and things like that. Joined the military to help pay for it all, and fortunately, I'm here where I am now, and loving what I do.
Fantastic. And what branch of the military did you serve in?
I was in Navy.
Well, thanks for your service.
Thank you, sir. Appreciate the support.
Sure. And Lena, tell us about your background. Where'd you grow up, and then how'd you get into law?
Sure. I'm originally from Buffalo, New York, upstate New York. A lot of people say it's Canada, but it's really New York. And I then came down to Florida, Tallahassee, Florida. My dad got a job down there. So I went from essentially New York to Florida, now here in Texas. Kind of similar thing. I've always, wanted to be an attorney and practice law. Actually, probate wasn't what I actually wanted to do. I wanted to originally do criminal law, and then I eventually wanted to do immigration, and then actually found love in probate. So that's where I'm at right now.
Very nice. So, oops, and there we go with I forgot to turn off the, what was it, their phone. Okay, so give me an idea, how do you find your practice position? You're in Texas. Are you licensed in Texas only?
I'm licensed in Texas only,
Oh,
all
right.
state and federal courts, and Lena's also in Texas. I think just Texas.
Yeah,
Okay.
not federal courts yet.
Okay. And so you're licensed in Texas, and then, so I know that probate tends to overflow with other areas of law. So I know you also do family law, and then you end up in other cases as well. What percentage of your business is, administration of probates or estates?
I'd say 30 to 40% of the cases is going to be probate and estate planning.
And just to add with that, we get a lot of clients who are interested in estate planning, and then, unfortunately they do pass, and we see down the line, we end up, getting their family members to come do the probate with us. So we see that a lot.
So in California, like everything else, we're very regulated. And really people who know about it want to avoid probate at all costs and get into estate planning. As I understand it, the probate process is a lot simpler in Texas. It's not you don't need to be as concerned about avoiding it. So how do you handle, or how do you explain, why should somebody plan ahead versus handling things during a administration in Texas where things seem to be a little simpler?
You want me to
Please, Lena. Yes, ma'am.
So I wouldn't necessarily say it's simpler. I mean, obviously everyone's going to want to avoid the probate process, especially when their loved ones die. It's already something hard for them to deal with as it is. I do always recommend, when they're doing their estate planning, to get as many assets as they can, a non-probate asset. So getting, their accounts with the designated beneficiary on it, setting up all their accounts so that they don't have to worry. And we have in Texas a revocable transfer on death deed. So we can do that with their homes and stuff, where we can transfer the deed to a beneficiary. We record it while they're living, and then once they pass away, we'll go to them. So I always recommend that, but a lot of times it's hard to avoid the probate process, because if you don't keep up with your assets and you don't keep up with making sure someone's designated as a beneficiary, you're going to end up having to probate.
So explain, because we don't have those revocable deeds in California. So when one's alive, you can make a deed that upon death, property transfers, say, to children, but it's revocable, meaning if I decide I don't like one of the kids, or they get married, or
you move.
whatever, or I move or get remarried, I can then retake that deed back and take it back. So it allows me to do some of the probate work ahead of time. I guess one of the biggest pieces.
Correct. It's fairly new. I would say it hasn't been around for that long, but yeah, I mean, essentially it is what it is. It's like a special warranty deed where you're deeding, your interest to somebody while you're alive, but it doesn't take into effect until once you pass.
One of the biggest challenges in California, and I think it's true in most states, I don't know about Texas, is that people often will get plans done. They'll meet with the attorney, do the estate plan, maybe create the trust and not move the assets in the trust. Maybe in your case, they do this revocable deed and they walk out the office with it. It's all perfect, but they never record it. Does that happen? And are there solutions in that situation where they've maybe done the planning, but didn't actually put the assets in the trust?
And yes, that happens quite often, actually. A lot of times people think that, that's where they're supposed to get a good attorney to, inform them and, do the work. And that's what we do. We actually do the recording process here. So, yeah, so we do it for them, and they put it in our hands and we take care of that, because I've seen that many times where they're like, I don't have to probate. My house is in a trust. And I'm like, I checked the property records and I checked the Harris County clerk, and it's surely not. So unfortunately, they still have to go through the probate process anyways. But even going back to trust, if your main concern is to avoid probate, I never recommend a trust for that sole purpose, because 9 out of 10 times they're going to forget to put something in the trust and they're going to have to probate anyways.
Well, I think to me it seems like, and I run a couple of Facebook groups and I get asked a lot about, estate planning attorney referrals across the country. And I feel like one of the minimum standards is what you offer, which is that you actually do the recording. I feel like to not do that as an attorney, well, we don't want to get involved in that. Well, but you're not solving your customer's problem, right? Just as a core as a business, our job is to solve the customer's problem, not, I guess you could sell them the map and point them in the right direction, but if that doesn't get the customer there consistently, then you're not really solving the problem.
Exactly.
So I really appreciate that you do that. In a case where somebody maybe does it, maybe they went to another attorney and had a estate plan done, or they went to an online service and they come back with a property, hey, this was supposed to be in the trust, but it wasn't, or it was supposed to have the warranty deed and it didn't have it done properly. In California, we have a hard to believe process called the Hegstead petition, after a famous case, Hegstead, where they did the estate plan, they deeded it out, I think for refinancing, should have put it back in, didn't, and the judge said, and I guess it went high enough in the court process where on appeal, it was ruled that, well, it was clear the intention was to put it in the trust, therefore we'll move it in the trust. So it's kind of like an after the fact, we'll fix things. In Texas, is there such a thing after the fact, or some other states are pretty much however it is how it lays?
So for a special warranty deed, that's a different story, yes, but not for a revocable transfer on death deed. Language specifically states it has to be filed before you die.
Got it. And if they didn't record it, then it really has no effect at all.
Exactly, correct.
And so to go to somebody, get that done and not get it recorded, to me seems incomplete. I know it's more expensive, your time, than to do it on my own. I know it's cheaper for me to take the deed and go to court, wait in line. But at the end of the day, if the job doesn't get done, what are we paying for?
And if you're not doing it right, same thing.
So you must, along the way, see people get other plans done that come to you and you have to administer them, and it causes problems. What are one or two of the biggest mistakes you see people make in their plans? Besides not planning, are there one or two consistent mistakes that you see happening?
Yeah, I can say one, and Bill, you can say another. But for me, it's making sure trust language is set up for children, for minor children. I've seen that many times because here in Texas, if you don't have that language set up, as we were talking about earlier, the court will force a dependent administration, even if your will allows for an independent. And I think we discussed earlier, I forgot the term you called it for independent. I think it was what was the term you called it?
In California, we call it limited authority.
Limited authority, right? So yeah, that's the biggest mistake, is not having trust language set up in the will for a minor child.
Well,
I guess for me, I know Lena's seen it as well, is not doing the self-proving affidavit, and therefore requiring us to have to call the witnesses and, oh my, just skip the damn process. Do the simple form with the package. It's only a 1-page add-on. It saves so much trouble down the road for our clients. It makes more work for us, yeah, I guess, but avoid it when you can. And it's so simple. It's called a self-proving affidavit.
Does California require that?
No, but it has a higher standard of proof, right? So you can have a handwritten will and just sign it, and it has a certain standing. And then if it's self-proving, then it's has more authority when the court evaluates the probate. So the self-proving, what you're talking about is where there's a signature by the author, whoever's writing the will, the decedent, I guess, and then there's 2 witnesses. Is that when you say self-proving? Is that what you're referring to?
Yes, sir.
Yeah. So it's documented, and you have the proper format. And that is there requirements of the witnesses? They have to not be family members or not have any effect. Can't be the attorney.
They can't be awarded anything in it. There can't be no special interest.
Yeah,
Yes, sir.
disinterested, over the age of 14. But yeah, it's same in Texas. The self-proving affidavit isn't needed to create a valid will, but like Bo was saying, it's needed to avoid having to get witnesses to the court to testify.
And I think it's found under Texas State Codes 251.104, if I remember right. And it gives you all the details, even I think a sample in it. But if you don't follow that completely, it doesn't count. But again, it's a simple, basic form to include to avoid a whole nother hearing and about $1,000 easy in terms of cost to your client when they're gone. That should go to their family, not to us.
Yeah. A famous movie on that subject, Body Heat. I don't know if you saw that with William Hurt. I think it came out in like the late 80s. But it was in Florida, and apparently in Florida, if the witness is disqualified, then the will is as though there was no will at all. And so in this particular case, this guy who had a new wife and family is trying to protect the old ones. As a result of the witness, everything went to the new wife, who was the criminal, the whole thing, it turns out, or the murderess in the whole process. So, but great movie if you're into probate and estate planning at all. I think it's really a must see. I know legally it's Florida, and it's different than Texas, but still it's kind of interesting concept. Okay, so we talked a bit about the estate planning. Let's talk. I know that you guys, and this isn't really maybe your main business, but we all come across people who, the parents had some assets. All they have is a house or real estate property. The heirs getting it have really no money at all, and it's a shame that in America, I forget the statistic on how many people don't have $500 cash. Mm-hmm. But oftentimes there's people who don't have the money to hire an attorney to properly administer a probate and help them through the process. What are you able to do there? Are you able to advance money based on the inheritance? Do you use a firm to advance money? What are some solutions for people who call and say, "Hey, I'm concerned about my grandma passed. I have this property, but I don't have the money to get the proper legal assistance."
I usually refer those people to some form of legal aid. And there's also at least 3 clinics here in Houston that they can go to, and all 3 of them have a probate clinic. And so if they qualify in the way that you're saying, they can't afford legal assistance in terms of the normal route, those are available. That's usually where I try to point them to. I don't normally front. We don't come out of pocket. No, sir. I need money in trust before we can typically move forward. We're a business after all. I still have to make sure my people get paid.
Yeah. I will say, I do have a partnership in an inheritance advance. So if they are clear that they're going to inherit a property, I can advance them, typically $10,000, $20,000 of legal fees against the property,
Right.
And that way the attorney goes forward. So oftentimes we'll end up picking, we can pick whatever attorney we want because we're providing the money. Versus, unfortunately, what happens is they can go to legal aid. Sometimes they don't get the time and attention. Then they go to an attorney who will take the case only because they'll take it on a contingency or could take the money in the back end. They're not business people. They're probably also not good attorneys. So if you come across clients that they have a house that's worth $500,000 they're going to inherit, but they don't have a penny, we can within 3 or 4 days get them $10,000, $20,000 cash or more if they need more. We get money to hold off foreclosures and taxes. That's something we do pretty regularly.
I definitely want to get more information on that, please. I want to know more.
Yeah. Okay, good. So, and then you're located in the Houston market. How far out do you typically, what other counties do you work in, or do you get where there's probate, so that, where people have property in Dallas, San Antonio, Waco, El Paso, or are those too far away for you to handle?
In my opinion, no, sir. I have a map on my wall, and I want to hit all 254 counties in my great state, and I'm not there yet. But right now, we've got cases as far as El Paso, Austin. We're mainly in Harris, Montgomery, Fort Bend, Waller, Brazoria, Tarrant County, the surrounding counties. But no, they want us to fight for them. We'll travel. But luckily with Zoom, we get to usually do it from our office.
Yeah.
But that is not a requirement. I don't mind jumping in my car with an associate and we run up there and kicking some butt. No matter where it is in Texas. They want me to go fight, I'll go.
Okay, so the fighters go to Bo, and what the people need a little more love or a little more support go to Lena. Is that how it works? Or how do
Yeah,
you,
I'm
Lena's one of
fighter
the
too.
associates I go with.
if you need somebody to be nice to you, go to Lena. If you need somebody to kill the other guy, you call Bo. So how do you guys work together? How's the business get split, or how do you organize your practice?
I'm the owner and operator of the company. Lena's hopefully coming on as a partner soon, so she'll develop more of those responsibilities. Yay. But right now she handles my civil side. She's pretty much, she does it all. Amazing. Handles consults, has her own team as well, additional attorneys and paralegals. Lena's is a special person. There's a reason I don't want to lose her.
Thank
Got it. So I would imagine already you must have relations with some real estate agents and or real estate investors that bring you some of these cases, right? They have a client who's inheriting a property or something's gone on. But you'll probably also have real estate agents who don't have a relationship with you and want to. How does a real estate agent work their way, earn their way in to having a relationship where they're bringing you business as well as you're able to refer them some business?
Typically, we always go to at least one or two lunches. I get to know the person. I do my own background checks on them. And then once we do all that, I don't mind adding people to the list. One of the few things that I do want from them is this. As an attorney, I'm allowed to get a referral fee. I don't want it. I want you to take care of my client. And by doing that, it's giving them that referral fee. Now, they get more business big picture overall by suffering that little bit, but my client also gets great service and a little bit more in their pocket for coming to us. It's a win-win. That's what I ask of my real estate people. And in the event that I get something back that they didn't take care of them, I expect to be able to discuss it and work with it. If I get too many, they don't get to remain on the list. You don't take care of my people, my neck is out there, you don't get to keep getting those referrals. So it boils down to we have to make sure we are in simpatico in terms of what we think is right and wrong, and then make the list and hopefully make people happy.
What do you see as one or two of the key distinctions between the people who do a great job and the people who do an average job as far as real estate agents servicing your customers?
Calling back, responding in a timely manner. I get they can get annoying. Trust me, we've worked with them too. But we also understand this is in the forefront of their lives. It is literally resting on their shoulders, weighing them down second by second. Get it off of them. Send them that quick email. Shoot them a quick text. They quit. It's the people who ignore them and just let it go. No, that's unacceptable. You need to respond exactly as we do. And that always means as soon as possible and always within 24 hours.
So if a real estate agent comes across a client who maybe inherits a property, grandma passed, left them a property, whatever the story is, they haven't started the process. What's a typical timeline if they have a will, but maybe not an estate? What's a typical timeline from calling on you to get the process started to being able to sell the process and distribute the proceeds? What's the minimum and what's the standard timeline?
So when it's like you said, a straightforward with a will, I would say I never give clients timelines only because of the fact that I've had cases where it was a simple will and then it turned into something crazy from there. But average, I would say,
You give ranges.
yeah, I would say about 3 months before they're appointed as the executor administrator. And then once they're appointed, they get the letters within 10 to 14 days. So that's when they would start the process. I don't recommend putting the house on the market earlier because if there's any hiccups with the court where we can't get them appointed, then that's going to obviously hinder the sale process. So I always say about 3 months before they can at least put on the market.
So in California, or at least in LA, if you were to file today, if I met with you and we fill out whatever papers we need to and literally filed today, we'd have a hearing date in about 30 days. I mean, maybe 35 days. Theoretically, if we did all of our job right, we'd have authority, verbally in court that day. We need the letters. Maybe it takes another 10 days. Is that the same process, but you're just allowing for potential corrections or potential hiccups in the process?
Correct. So same thing. Arguably, we could probably get a hearing date within 30 days if we file everything properly at the first time. The posting requirement in Texas is 10 days, so it just has to be posted for 10 days.
Right.
And then after that, as soon as it's been 10 days, we can technically set it for a hearing, but the courts, at least here, are very behind. We're not getting hearing
Got it.
dates right now for a good 2 to 3 months out sometimes.
Gosh, can I brag a little bit? There's one thing that we do in LA have in our LA County Court, which is the largest probate court in America. Is we were behind, but we are back. We've been back at 30 days for about 6 months now. So that's one area that we've. Everything else is a mess, but we get that first hearing in right away. So that's good news.
Nothing against our courts at all. I think they're doing a great job. They have more cases than I'd ever want. I mean, it's crazy. But I don't remember a time we were ever at a 30-day turnaround in terms of getting a hearing.
Oh, wow.
So, and then COVID didn't help. I mean, the courts were literally shut down for a period of time, and the cases didn't stop coming.
Yeah. How is the court process today different than pre-COVID? I mean, in LA, we shut down, went to video. Now we're kind of back opened up with video to some degree.
Now it's our time to brag about our courts. Tell me about the 1 minute prove up.
Yeah, so in Texas during COVID, they started what's called a 1 minute prove up. It's only for obviously cases where there's a will, of course, and the court reviews all the proof of death and all the facts prior to the hearing. And we only have to ask them 5 questions that they specify. And it's literally, they call it the 1 minute prove up, but not all the courts do it. It was only like 2 of the courts in Harris County. But to answer your question about, since COVID happened, yeah, I mean, we having to be able to have the option of Zoom has been amazing because it's opened the world for probate. We're able to get witnesses that, maybe we couldn't find here because they were in a different country. We're getting them able to testify because it's over Zoom. So our courts have actually gone back in person, but they still give you the option to do it over Zoom, which I think is awesome.
So the 1 minute prove up is at the actual appointment hearing?
Yes, correct.
So can I brag back on Los Angeles and say that we handle those questions on the filing, and theoretically, if it's in the file, the court will recommend for approval unless somebody walks up and objects, and just approve it. You even have to go to the hearing. There is no hearing unless there's an objection or unless there's a deficiency in the documents. They've actually streamlined that process. I have to say, our probate court, the presiding judge really has their act together because that's the one thing we do really well in California. Everything else is a mess, but that we have done really well.
Look at him one-upping us over here.
Yeah, well, I'll brag on California.
When Lena runs for judge, what kind of changes she'll make. She'll be looking at California. I wish they would. Is that we were ecstatic not having to go through the long hearing. We're like 1 minute.
Right.
There's prep work. The reason why you get 1 minute is we did all the work before.
Right.
It is so awesome. You come in, boom, 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 boom. You're done. Yeah, you're good. Let's go.
I will say, as a real estate agent, I am surprised at how little interaction is amongst the different states on procedures. For example, we still require on a court-confirmed sale, I think what you called dependent, when the court has to approve the sale, that process happens live in court, right? And so you sell a house for $500,000, you go to court that day, and if somebody is willing to show up and bid 5% plus 500, which is 525, and they show up with a cashier's check for 10% of that made out to the estate, and to waive all contingencies, they can bid on the property in court. And the challenge there is when the court was so closed down that you have to show up and bring your client. They'd have to bring a cashier's check, and the attorney would have to be able to verify the check before the court process. Whereas in other jurisdictions like Las Vegas, Clark County, Nevada, they would require the check the day before, so the attorney could check it the day before. It seems insignificant, but that would just eliminate anybody from having to go to court. And so I learned that by watching. I mentioned that to the presiding judge in LA, and I think they're taking that in consideration. But it seems there's not a lot of cross-pollination. That the law business is very state-centric. Well, of course, the laws are state-centric, but the procedures, there's I think best practices that could cross-pollinate and help all the jurisdictions. And that's why I do this series. I've interviewed attorneys in about 10 different states now. It is interesting how each one state has some little different nuances along the way. So if you were giving advice to a real estate agent or investor who wanted to get involved in real estate and wanted to learn the procedures and wanted to learn the process and wanted to learn how to assist their clients through the estate planning and probate, what resources would you point them to help them learn that process, or do you have any?
Well, to us first, I think they're the best resource to sit down in that room, hear about your specific case, because it could vary as we know by the facts. I mean, we have generalizations, but a small little snafu. Next thing you know, we're going down this road, not that straight road that we thought. So I think it always starts with going in and speak with an attorney that has experience in that state in the courts, and then that's your first start. But if you need resources to get there, probably TexasLawHelp.org is the number one I send people to. It's produced by the State Bar of Texas. I mean, the same people who says we get to be attorneys. They developed the bar exam. Hopefully that stuff's reliable, and the things that I've read have been accurate. So that's normally where I send people if they insist on going pro se or trying to do it on their own. I do discourage that, but I'm a little biased.
No, I meant not so much that. I meant like a real estate agent who wanted to learn how to work with attorneys and work with, help the client and present. I think I was throwing you a softball to your podcast, actually. So let me rephrase. Bo,
Yes, sir. Sorry about that.
I understand you have a podcast on the subject of law in Texas and it crosses into probate law. Tell me a little bit about your podcast and what you try to do with that.
Yes, sir. I do have it's an internet radio, if I remember right, and it's Bo Knows Law. I have it every Wednesday morning from 7 to 7:30. We play it back again, the same one we play in the morning on Wednesday again at 5 to 5:30 p.m. And I answer questions people have emailed me at bowenlawradio@gmail.com. I have a small bank and I try to answer 3 to 4 questions a day. We also add in some essential Latin for people who are trying to do it on their own. We also usually have a dad joke of the day to send you home. Little things just to keep the morning going and trying to help.
Okay, so we'll put links for the podcast in our show notes and make sure they have a chance to see that as well. So great. If somebody was interested in reaching out to your firm for questions regarding a probate with a real estate investor or a real estate agent, or maybe they're just a family that has some questions, how would they best get a hold of you guys?
They can reach us by phone at 713-574-7777. That main line again is 713-574-7777. They can also find us online at www.bowen, BOWENLF, as in law firm.com. That's Bowen, BOWENLF.com. We're fortunate to have 2 locations. We're conveniently located off of 290 and 1960 at 13103 FM 1960 West, Suite 216, in Houston, Texas 77065. We also have our home location in Champions at 14202 Champion Forest Drive, Houston, Texas 77069. You can also find us on all the social media: Facebook, LinkedIn, Instagram, Twitter, YouTube, TikTok, Google, you name it, and more. I try to get it out there for everyone. If they need help, we're here.
Fantastic. Well, I appreciate so for any real estate investor, agent who has clients who need assistance, or if you're a family that has questions regarding preventing probate or making your plans ahead of time, or if you have property that you need some help with, feel free to reach out to Bo and or Lena at bowenlawfirm.com, bowenlf.com, and the phone number. Guys, I really appreciate the time with you guys today. I really learned a lot myself and appreciate learning with you.
Thank you.
Thank you, sir.
Thank you for having us.